Hello and welcome to U.S. LawShield Live. I'm independent program attorney Richard Hayes, joined by the wonderful independent program attorney Emily Taylor. Hello, Emily. How are you today?
Good morning, Richard. Doing good.
All right. Today we have an incredible topic for you. We're talking about domestic violence and your right to self-defense and how it those two play off of each other. But we're talking about what that is, how it affects your right to self-defense, and how it can affect your gun rights overall, because there's a lot of misconceptions here, and a lot of people fall into some traps when it comes to domestic violence because, sometimes it looks like a speeding ticket and you could lose your gun rights forever. And so it's important that we talk about this. We gathered these questions from a previous LawShield Live, and we've just started the broadcast. If you are here in the chat, make sure to give us a thumbs up. Make sure you're subscribed to the channel and leave a comment about your questions related to this topic because we're early. We're early in this discussion, and we have a good chance of getting to them. Emily's getting them fed to her right now live. We're on Facebook and on YouTube, so make sure to leave a comment. They're monitoring that for us. But to start off the conversation, Emily, when we talk about domestic violence, and I know it's not called that everywhere, but what does that mean?
Yeah, so we can, think generally sort of what does domestic violence mean? And, if we're not speaking from the actual codes and legalese, we're really talking about violence that occurs between household members, right? And that can be spouses is what we think of mostly. We think of children. We think of, sort of this very, very close contact relationship. Now, that's our colloquial understanding of what domestic violence is. But it's important to note that there's going to be specific definitions, both in federal law and in your state's law, that's going to define exactly who qualifies as a family member, such that if you get into this assaultive interaction with someone, you may risk being charged with domestic violence or domestic violence offense.
Yeah, and this question comes up a lot from clients. Is domestic violence the same thing as family violence? And going to your point exactly, it's going to depend on what your state considers it. But when we look at federal law, we're looking at current and former spouses, children, siblings, people similarly situated into state-specific. Texas is a good example. People who cohabitate. That could be your roommate in college. It could be a girlfriend. Our definition is much more encompassing, and we see that trend across the states, that the state's definitions are a little bit more broad.
Oh, yeah, absolutely. You may hear, and I'm already skipping ahead here, Richard, to what is the boyfriend loophole, which is one of our sort of pre-populated questions here. But, skipping ahead to that question, which is, the states generally have more expansive definitions. So I guess that brings me to what's the boyfriend loophole?
Yeah, so you'll hear this called the boyfriend loophole or the Charleston loophole.
By the way, anything called a loophole, automatically comes from the anti-gun side because
exactly right.
Yesterday's reasonable compromise is today's loophole, according to the anti-gun people all the time. But go on. And
I'll use Texas as an example to illustrate this point. So under federal law, they do not consider people in a dating relationship as being, if that person were one of the members of that dating relationship were to assault the other person, under federal law, that would not qualify as a misdemeanor crime of domestic violence.
Well, absent something very specific, right? Like you share a child.
Correct.
Or, similarly situated to a spouse, right, is something that we see under federal law. So that could include, you live together, but you're only dating. But this sort of, I know what you're talking about, which is just this very simple, like, oh, I've been on a couple dates with this guy over the last couple weeks. Right.
Yeah, not going to qualify. But if, let's say, you cohabitate, what if you hold yourself out as, oh, that's my husband? Or, at that point it changes a little bit. But to contrast it with many states have, dating violence. They'll say, people who have a dating relationship, they are going to qualify as household members or part of this domestic violence kind of umbrella. And so that's something you have to be on the lookout for because, that comes up from time to time.
Oh, yeah. And, be aware, too, that if, like, let's say, you're in a state that says, okay, the guy that you've just been dating, right, or the girl you've just been dating, that is a family member or someone who qualifies, who you could domestic violence assault and be charged with that offense. Well, just because federal law doesn't include that person, that doesn't get you off the hook if you get charged and convicted with a family violence or domestic violence crime in your state, right? So, it is, again, I hate the word loophole, but even if you like the word loophole, it's not really a loophole, right? Because the states are completely picking up the slack and federal law is kind of feeding into it.
Yeah. And that kind of brings up the next question that I think comes up in this discussion is, a lot of people think that my self-defense rights are your right to defend yourself, maybe from an abusive husband, maybe from an abusive wife, or, one of these people that qualify or fall into one of these categories, that your self-defense rights change simply because of the nature of your relationship. Now, there's a ton of considerations that go into it, but just our bare bones self-defense law, what do we see across the states as far as, does it change self-defense laws?
I don't see this changing self-defense law at all. We have now practical considerations of reasonableness of what your jury's going to think, prosecutors, police, and I know we'll address that a little bit more later in the program here. But when we're just simply talking about, are there exceptions in self-defense law for defending yourself against a spouse? I mean, the answer is, broadly speaking, no. I have never seen a penal code or a criminal code section that says this is when you get to use self-defense, except if it's your husband you have to defend yourself against, or your wife.
Yeah,
right?
I'd say just the opposite. Yeah. For example, assault under Texas law says assault is intentionally, knowingly, or recklessly causing bodily injury to another person, including your spouse.
Right.
At some point there was some debate, hey, I guess assault doesn't apply to your spouse. So they went in and specified in our law, and we see that come up.
In many states.
In many states. So, but going to that self-defense discussion about how it impacts your self-defense rights. So the law is going to remain the same, and our general self-defense principles are still going to apply. Needs to be immediately necessary or reasonable under the circumstances in response to an imminent threat, and depending on the amount of force that's used, whether it's something that would hurt, think punch, grab, tackle, restrain, whether it's a use of force or physical force, or something that might cause serious bodily injury or death, deadly force as we know it, that doesn't really change how the law is going to apply. But what about, and this is where I think the juries come in and they start second guessing and they start, picking things apart. Whenever I see a self-defense case involving, what would otherwise be, a misdemeanor crime of domestic violence, usually there's only two witnesses. And I think that plays on a lot of juries, wouldn't you say?
It does. And, we have to consider as well that these cases, they end up going to trial a lot,
yeah.
Right? In fact, when you go to larger counties, larger DA's offices across the country, you're often going to see entire divisions of DA's offices where they are specially trained to only handle domestic violence cases. Reason being, they are so particular. There's going to be a lot of, hey, he or she started it. I was just defending myself.
Right.
That's a huge defense in these issues, right? And you're also going to see a lot of he said, she said, and a lot of people recanting their stories, right, and changing stories. And so we have, this unwillingness by prosecutors' offices to drop these cases, right, for that reason. So we see these cases, you have to defend yourself against a spouse. You are way more likely to hit the trial stage or to be, feel like you're forced into a plea bargain, which means your self-defense rights are really, really your gun rights are really, really on the hook.
Yep.
But, I think also there's like a degree of skepticism that comes into all of these as well. Anytime, and I think it's, we can expand beyond domestic violence a little bit, anytime you defend yourself against someone there's going to be a lot more skepticism and a lot more attention paid by police, prosecutors, and juries about, did you really need to do what you did? Because this person, you're related to them maybe. Did you really have to defend yourself as opposed to the mugger who comes out of the dark alley?
Yeah,
right?
And, juries like that. I mean, they like it when you have your innocent party kind of beat-bopping along, and then they're forced to respond to a threat. They love that all day long. What I think gets a lot of good folks in trouble and is because when you have a trial, and we do this in Texas, we have a bifurcated trial system where, you have your kind of snapshot. Did the incident occur? Did it not occur? And then if they find the person guilty, they go on and explore kind of like a photo album. They go look at their entire life and see, what punishment is deserving of this person. And I think juries, because they're limited, they have these blinders on and they're just looking at the incident at hand. They don't get to see all the history leading up to it. They don't get to see how it escalated maybe over a long period of time, because most courts will say, hey, that's not relevant to this incident. And so I think that also brings a heightened level of kind of scrutiny to these cases. I mean, I'll say when I was a prosecutor, we treated we treated family violence cases, domestic violence cases different than our typical assault cases. And it's for that very reason. And when prosecutors are being trained, they're told about, all of these statistics with misdemeanor crimes of domestic violence. For example, this is what they tell us, an abuser will abuse about 8 times before the victim will report it. Mm-hmm. And so, you see, hey, not only are you, and it gets in the prosecutor's mind, not only am I prosecuting for this one instance that this, boiled over and this was reported, we're trained, based on the statistic, hey, this has happened a lot. And so we're really, it kind of heightens the stakes.
Yeah.
And
you're trained that it's going to get worse and that it may end in death. And so then you've got a whole lot of prosecutors who don't want to see their name splashed up on the front page of the newspaper because they dismissed a case based on self-defense that was a domestic violence case. And then later the person went on to kill the other spouse.
Yes. And that's, that's kind of leads into the next question that comes up, which I think is, are these felonies? Because if we look at our prohibitions, we'll talk about gun rights now. When we're looking at the prohibitions on possessing firearms, purchasing firearms, we have 2 big disqualifications that come up. The first one is, are you a convicted felon? And would you, and this is something, I think this is one of those myths that needs to be dispelled. Is every crime of domestic violence a felony?
Absolutely not. And it's really going to vary based on your state's law. And again, if you're pulling up your state's law and you have an online platform to search, that's great. Most states' legislatures have that. You might be searching domestic violence. Also try searching family violence, right? Because those are kind of our 2 operative terms. But you will probably see a variety of different offenses, many of them misdemeanors, right? Yes. And so we have this basic level. I could just shove my spouse, and that's a crime of domestic violence, right? I could make a verbal threat against my spouse at home. That's a crime of domestic, well, not necessarily at home, but that's a crime. I just hope that, you're not making gigantic threats in public. That's a crime of domestic violence, right? So it can go anywhere from these very, very low level, you mentioned earlier, traffic ticket level offenses up through, in every state, so you're going to want to look it up in your state to see when it starts becoming a felony, because states have lots of different sort of almost ticky-tack rules based on this data we were talking about earlier, right? About when things escalate, how likely they are to escalate, how likely something is to result in death. So, for example, most states make strangulation, right?
That's a good one.
That's a felony offense.
Not a good one, but that's a good example.
Good Lord. That's your felony offense, right?
Yes.
Or, something like, well, you've been accused of domestic violence several times within a certain period of time.
That's another good example,
we call it, a continuous or an ongoing, right, crime of family violence. That's often going to be a felony. And then, of course, when you start causing serious damage to anyone, not just your significant other, that's generally going to be a felony as well. But it really does vary. And it's good to point out that these little, even the ticky-tack misdemeanor crimes, if they are charged and convicted of family violence, you are in a lot of trouble when it comes to your gun rights.
Yeah. And so when a lot of people, I think, are under that misapprehension, hey, I'm not a convicted felon, I should still be able to buy a gun. We have this second prohibition under 18 U.S.C. 922 G9. That's where it lives.
You're the code memory guy.
That's the misdemeanor crimes of domestic violence, and it's defined in 18 U.S.C. 921 A33. That's where we get our definition. If you wanted to look up our definitions for misdemeanor crimes of domestic violence, and going back to, and we have to put emphasis on these low-level offenses, these traffic ticket level offenses where it's a fine only. You would never spend a day in jail, based on your state's law. But what the government is looking at, the federal government is looking at, is it's really 2 critical elements. The first is there an element of force or threatened force? So it does, we know what force is: punch, grab, tackle, restrain, threaten serious bodily injury or death. But it's a threat of force. So to your example, I'm going to kill you. That's a threat of force.
Oh, yeah.
And so that's element number 1. And then they look at who is that force or threatened force used against. And if it's one of these people who falls into this category of somebody would be in a domestic violence relationship, then you are going to satisfy the disqualification. That means, you could say, I'm going to kill you to your spouse. If you're convicted of that crime, let's say you plead guilty or you go to trial, a jury convicts you, you are barred from possessing firearms and ammunition for life. You can't buy a gun anymore under federal law. And so it's very important. I think kind of the takeaway for this, it feels just like a speeding ticket. You wouldn't want to get a lawyer involved, but you could lose your gun rights forever and it's really important to get an attorney involved.
Yeah, and I mean, I think we need to elaborate on that and just make this very, very clear, because we saw, I mean, over the course of our time just practicing gun law over the last decade, we saw a shift, right?
Yes.
In how the FBI actually digs into these things when you are trying to purchase a gun. So, I mean, I would say 10 years ago, if you went in to purchase a firearm and they ran your NICS background check and it came back that you had been convicted of misdemeanor assault.
No mention of domestic violence, no mention of family violence.
No mention. Fine. Ding, green light, proceed, buy that firearm. Today, completely different story, because now when the FBI sees you've been convicted of misdemeanor assault, they're sort of, we call it going behind the curtain, right? That's when we talk about it just colloquially around the office. They're pulling that curtain back to say, who was the victim?
Yep.
So even though your charge doesn't actually read family violence or domestic violence, the FBI is often investigating and pulling those documents and asking, you know, or just simply denying you and telling you to prove that it wasn't a spouse or someone similarly situated, you know, it wasn't a crime of family violence before you have the right to purchase your gun.
Right.
It is really, really, I think, tough on people who, particularly, let's say, they've been buying guns for ages and ages and ages.
Right.
All of a sudden, they're getting denied, and they want to appeal it and they want to challenge it. And when we look at the crime and we say, oh boy, well, that was against the woman you were living with back in 2004, you know, there's really no challenge to be had here other than resolving your record, which we could talk about later. I think that's a question that's already come in.
Yeah.
I mean, it's tough for people to hear that.
Yeah, and that comes up. Think even worse than 2004. Go back before the Brady Handgun Violence Against Women Act. You know, how are you want to categorize it? And this question comes up.
Well, let's actually. John asks.
Okay, let's hear it.
If a person had domestic violence over 2 decades ago, no other crimes on his or her record, can they buy a firearm? And if not, why? And if not, how can they get their rights restored? So there's a lot of good questions in there.
Yes.
But let's talk about, Brady was passed in 93.
Yep.
Correct? So what happens if you were convicted of domestic violence before 1993 when this wasn't the law?
Right. And I'll answer, there's kind of two caveats to this, because I know a lot of folks will say, hey, that law was ruled unconstitutional by the Supreme Court. Congress reauthorized it. And what they did is they added some findings of fact and conclusions of law that basically cut the court off. And so that is the law of the land right now. And then the second question we get of, that sounds ex post facto.
Doesn't it, though?
Yeah.
Unfortunately.
So 1993, let's say the conviction was before 1993. You know, why that wasn't the law of the land at the time that I entered this plea. Why should it be held against me? And the answer is...
because the courts say that it can be.
Yeah, the courts say that it can be. And they say it's not ex post facto, therefore it's not ex post facto. And so if you have one of these old convictions, it is going to be a disqualification.
Yes.
Like we said.
Even decades ago. Even with a clean record afterwards. Now, that is assuming your state doesn't have some sort of mechanism by which charges are automatically dropped, expunged, and all of your civil rights and firearms rights restored.
First offender.
Exactly. Some states have that. It's great. That is not the majority of states.
No.
The majority of states, if you're convicted, you are always convicted until and unless you take those affirmative steps to clear your record. That's going to be on the state level, whatever your state's expungement or expunction process may be. It might include convictions. Some states do if it's the only one and it's been decades and decades.
Right.
Some states are very, very harsh. Texas is one of them. If it's a conviction, it is going to be, with very few exceptions, it is going to be a pardon by the governor.
Right.
Is the way to restore those rights, with the additional caveat that the governor then has to also pardon you and authorize that your firearm rights on top of it
not
are
just
restored.
enough that you're pardoned. You have to have your gun rights restored.
Yeah, you have to have a special pardon.
Right.
And if your crime happened to be on the federal level, not the state level, then the state can't do anything for you at all.
Right.
Then you're looking at a presidential pardon, essentially. So
yes. And I would say one more, and it's going to depend on the state that you're in. We have some states, courts don't lose their jurisdiction over someone. We have a handful of states that do that, and maybe judicial clemency is the way that you go. You file a motion for new trial, and then the court dismisses it. And so it's really going to depend on your state, and there's so many different procedures. I mean, it would take us days days to go through all of them. But you need to speak to an attorney in your state. If you find yourself in one of those situations, they're going to be able to advise you, hey, how do I get my firearms rights restored? In virtually every state, there is a process. Now, your odds of success or the likelihood of succeeding, that may vary quite a bit, but you need to speak to a lawyer in your state.
So we have someone asking, what if you're just charged with domestic violence, but the case is pending, so you're not yet convicted? How does that change things?
So it's going to come up in a couple of different scenarios. Now, the first one to be on the lookout for is conditions of bond. All right, and so that's when, the general rule is that you stay confined until your trial. Now, the vast majority of states have a bonding system or a personal recognizance system or a no bond system where you're let out, and as long as you show up to court, you follow the court's rules, then you can stay out in the free world until your trial day. Now, a lot of courts will say, as a condition of us releasing you from being confined, you do not have the right to possess firearms or ammunition. You need to dispossess yourself of these. And that comes up a lot. We see that over and over again. But the next one that's really important is protective orders. Now, a lot of courts will issue a protective order. Essentially, it's saying, hey, look, defendant, person charged with this crime, the complaining witness or victim, you are restrained from threatening, harassing, assaulting, stalking, all these different types of behaviors, and that's going to qualify as a protective order both under federal law and under state law. Most states will have some extra crime of saying, hey, you violated our protective order. It's going to be a crime on top of the crime that you're already charged with. And so when those come up from time to time, just know that just because you're not convicted does not mean that you cannot purchase or possess firearms or ammunition. So you need to speak to the attorney handling your case.
Absolutely. So let's get to a couple more questions. We have, quickly, this is a great one. Wes from Facebook, what's the best way to search if it's still domestic violence, if it involves an ex-spouse and or parent of your child? So Wes, I'll tell you, first of all, I don't know of a single state where ex-spouse or parent of child is not defined as family member.
Right.
Doesn't mean there's one out there I don't know about.
Yes.
But that is almost certainly going to be a family member for the purposes of domestic violence or family violence.
Yep.
It is under federal law. Under your state's law, check the codes. And like I said, virtually every state I know of has an online system. You're going to search family violence, domestic violence. Also search family member. Search your criminal code, your penal code, search your family code. You're going to find definitions, see what they say. And if you're confused, get a hold of an attorney. Attorneys both in the family law realm and the criminal law realm are going to know these off the tops of their heads.
Yeah.
So, Richard, I'm going to toss this one over to you.
Okay.
If there's a record, this is from YouTube, if there's a record of domestic violence with the police, right, so you've been called out to the house before.
Yep.
Are you going to be more likely to be charged and convicted because there's this past history?
I would say probably yes.
Probably.
Yes.
I think so too.
And so going back to a comment that we made earlier about, these prior instances generally not being allowed in, to show kind of the defense, okay? Most states flip that on its head when it comes to, is this admissible against you? Not to prove your defense, but to prove that, hey, this is you acted in conformity or your
modus operandi.
Your motive, opportunity, motive, lack of mistake, identity. That doesn't come up so much because usually your spouse knows who you are. But to prove lack of mistake or to prove, if you say, hey, I'm not a violent person, maybe it opens the door.
It all comes in.
And they all come in and say, well, he lied to you when he said he's not a violent person, and here's all these prior instances. So it does create some landmines. And as far as, the police coming out to the scene, I've talked to several police officers who, they get annoyed. I mean, they're human beings and they get annoyed coming out and having the same talk with the same people every week. And sometimes they just want to, all right, I'm want to.
Oh, yeah. Look, personal story here from being a prosecutor. It's not about domestic violence, but it's this idea. We had one police department who had given this one particular guy a break on his DWI like 6 times. They had caught him, and he was a firefighter, and so it was a kind of fellow badge member, and they were trying to give him a break, and they kept catching him and driving him home and giving him a break time after time after time. And then finally they got so sick of it that they said, all right, buddy, you're under arrest. And they did the worst DWI arrest investigation I've ever seen in my entire life as a prosecutor. And I wasn't allowed to dismiss it or reduce the case, even though generally speaking I would have been like, sorry guys, do better next time and I'll get you a DWI conviction. I wasn't allowed because the police were so angry and they'd given him so many breaks that they had talked to my boss and my boss's boss, my boss's boss's boss, who had said, sorry, move forward, even though this is a really crappy case.
Yeah.
So it happens, and it happens in way less serious crimes than domestic violence.
And if you have previous convictions, I'd say that one comes up a lot as well.
Yes.
You know, if this person was charged with a domestic violence crime, let's just assume it's a misdemeanor, and it was dismissed or reduced, or they got some kind of deferred or pretrial, or they got some kind of good deal. Let's say they got a good deal.
Oh yeah, prosecutors are not going to give you a break the second time.
Yeah, second go around, third time go around, you're not getting a deal anymore. So it does come up.
Yeah. Okay, let's look at, so Jennifer, this is a really good question, Jennifer, and I'll start and I'll let Richard jump in. I don't know that we have really great answers for you, but it definitely needs to be addressed. Jennifer, what is a victim supposed to do when the abuser does not abide by the order of protection? That is really, really tough. The answer is call the police every single time. And that's really the only answer I have, is that they are in violation of protective order. That is a crime in virtually every state. If you are under protective order, there are some states, Texas is one of them, so I can speak to that specifically, in which you are actually entitled to an expedited LTC because there's currently a protective order and you're being protected. So the DPS has to issue you a handgun license within days if you ask for one. So there are protections there, but other than call the police every time and make sure that you are arming yourself out of safety. The problem I know, and I'm sure this is Jennifer's frustration, is you call the police and the police say, well, he isn't here now.
Right.
What do you want us to do about it?
Right.
And it's really tough on victims. Do you have any other advice?
No, it's the same advice I give for people who are being harassed.
Yeah.
Communicate the unwanted behavior. Hey, don't talk to me ever again. Communicate it to the police. The important time, and maybe the police aren't super interested the first time it happens, but documenting. Maybe they don't care about the second time or the third time. Fourth, fifth, sixth, seventh, at some point it's going to get their attention that, all right, this is rising to some level of criminality and we need to act on it. And then on top of that, let's say you're the victim, you have rights. At the trial of the perpetrator, the domestic abuser in this case, that would likely come in at some point in trial to prove, hey, this person is a violent person. This person doesn't follow the court's orders. This person was given specific instructions to leave me alone, to not threaten me, to not harass me, and he can't follow those rules. And the only place to keep this person from harassing me or assaulting me is when they're confined. And so it really could affect the punishment outcome in a case.
Yeah. So I'll address this one really quickly. This is from YouTube. How do I find out if my brother has a felony domestic violence conviction? He thinks he does. He took a plea. How do we know? This is a good answer for across the country. I'll tell you, wherever you are located, figure out where that charge took place, right? Whether if it was a municipal charge, the city, if it was on the higher level, right? If you actually went to a county jail when you were arrested, it's the county. Find the county or the municipality's district clerk or county clerk's office. Call them. You just need to give them your name, your date of birth, your general identifiers. If you know about what year it happened, that's also great. That helps them pin it down. Ask them for, and this is very important, write it down, your disposition paperwork. Those are the key words that are going to trigger the clerk's office to say, oh, we need to know what the final result of the case was, right? That disposition paperwork is going to tell you what crime you were convicted of, if it was a conviction, if it was deferred, if it was a dismissal. That's your ending paperwork in the case. That's absolutely what you need, and that is the best way to definitively find out if you are a convicted family violence offender.
Yeah, and I would say there's another resource, although I'll say is not as accurate as the process that Emily laid out, but the FBI does have what are called criminal history summaries. And that will have some information to it. So let's say he doesn't know the year, or he doesn't know what county it took place in. It's 18 when it occurred, and now he's 60. You don't remember everything. Maybe a good place to start would be the FBI criminal history summary, and that might give you some of the details that could lead you to the path that Emily was describing.
Yeah, and then I think this is the last one we have time for, but I think it's important to address. This is Teresa from YouTube. What if an abuser harasses friends of the victim? What can you do? So a couple things. First, there may be a provision in the protective order. Get a printed out version of the protective order that says that you can't essentially communicate with the person who's protected through other people.
Yeah, through a third party is what they'll normally say.
Exactly right. So check that. They may still be in violation, right? Yep. Number one. Number two, even if they're not, even that provision isn't there there may still be a harassment law, a stalking law, right? The best way to trigger that is in whatever platform, right, in writing somewhere, whether it be email, your Facebook messages, text messages, do not contact me again. Clear, definitive statement.
Yep, unequivocal.
Unequivocal statement. And then stop responding once they continue to reach out, send messages, phone calls. Hopefully you have triggered your state's law. Every state's a little bit different.
Right.
But, laying down that boundary and then not re-engaging is the very important part. So it could be that person who is harassing the friend doesn't get charged with another crime against the original abused, but might get charged with a crime against these other people.
Yeah, and a part that Emily said that I have to reemphasize, because you want to have all of your rights as a crime victim, that unequivocal, stop contacting me, and then do not respond to them anymore, report it to the police. What I hated to see as a prosecutor is when I see someone harassing someone just over a long period of time, and then I see them re-engage in the conversation, and it really takes the wind out of your sails, saying, hey, I was being harassed, when you see the person voluntarily engaging or going back and forth with this person. So unequivocal statement, cut them off, and then it takes restraint, because it can be very, very frustrating, but you need to not re-engage, because if you want a good harassment case, that's how you build it. But we hope you enjoyed this discussion. This is an incredible topic. Please keep your questions and comments coming. This is how we source all of these discussions, from your comments. So make sure to leave a comment, and we'd love to talk about that topic in a future video. Also, make sure to like this video. If you enjoyed this discussion, like it, subscribe, and share it. Share it with your friends. It's a pretty important topic, I would say.
Absolutely. And until next time.